Hello and welcome to Newscentre. The Parliamentary Committee on Finance has red-flagged anti-competitive practices of big tech companies in the digital market and has called for an ex-ante framework legislation and identification of players that can negatively influence competition. The Parliamentary Committee has called for a Digital Competition Act to regulate competitive behavior in digital markets. The report goes on to say an ex-ante framework is must to evaluate anti-competitive behavior before markets are monopolized. The CCI needs a digital markets unit to strengthen the ability to regulate digital markets, and this ability is lacking right now. Significantly, the committee has said systematically important digital intermediaries must be identified, and they would be made to inform CCI before any mergers and acquisition or concentration. These intermediaries must not use any data not publicly available. The panel has also said that the government must focus on anti-steering, platform neutrality, bundling and tying, data usage and deep discounting. Currently, the CCI is an ex-post framework which kicks in when anti-competitive practices are reported, and we need an ex-ante framework to prevent any moves or actions towards eliminating competition or distorting markets. This is what the report by the Parliamentary Committee has said. Who all deposed before the committee? The Competition Commission of India, the Ministry of Corporate Affairs had testified before the committee. They also demanded this ex-ante framework. The other people who deposed before the committee and testified were the likes of Amazon, Apple, Facebook, Google, also the likes of Paytm, Ola, Swiggy and Zomato. I caught up with Jayant Sinha, chairman of the Parliamentary Panel on Finance and BJP's Lok Sabha MP. I began by asking him about the necessity of an ex-ante framework in addition to the existing competition law.
We are taking two very major steps in our competition law framework in the current period, Parikshit. One, of course, is the competition law, which has been amended after 15 years, on which the Standing Committee on Finance has provided its suggestions, and the government is now considering it. We are very much hoping now that we have provided our suggestions and views, that this will get passed in the budget session of Parliament. And that's a very major step forward. After 15 years, there are very substantial amendments that have been made to the Competition Act. The second and equally important set of changes that are being recommended deal with the behavior of systematically important digital intermediaries that are operating in digital markets, and to ensure that we have sufficient competition in these digital markets. We think it's very necessary to have ex-ante regulation. So the Competition Act, the way it is set up right now, is meant for ex post, that is after the fact, abuses of market power. But in digital markets specifically, it's very important to have before the fact ex-ante restrictions on competitive behaviors, because it has been proven time and time again that these important digital intermediaries, digital platforms engage in anti-competitive practices, and they have to be restrained ahead of these practices actually crushing competition in the marketplace.
Right. You heard extensive arguments and submissions from the big tech players like Apple, Amazon, as well as Paytm, Ola, and many of the domestic tech companies. What was the view that came out, and why do you feel that there is a need to protect interests of domestic companies?
You're right, Parikshit. We held extensive consultations over a full year to speak to both the traditional big tech companies, as they're called, the Apples, Googles, Microsofts, Facebooks, all of these people. We heard their views. We also heard the views of our companies in India's digital ecosystem, which are startups, larger companies as well. You named some of them. We also heard the views of the government, the Competition Commission of India, academic experts that have studied this. And even as we consulted with all of these different stakeholders, we also studied very, very carefully the way in which competition law is evolving around the world. And let me just tell you that in the EU, they've already passed a Digital Markets Act, which is based on the same concepts of identifying systemically important digital intermediaries and then restricting their competitive behavior. But very similar legislation is being considered in the United States, in the United Kingdom, and in other jurisdictions as well. So competition law in digital markets is absolutely evolving in this direction. And the reason for that, Parikshit, is that digital markets are very different from traditional markets. Here, we often see winner-take-all effects, monopolistic outcomes, and because these markets tip so quickly, because there are very powerful size effects, network effects, and so on, it becomes important to ex-ante regulate them, because if you've established dominance in one market, and of course are engaging in unfair practices there, it becomes very easy for you to continue that in adjacent markets as well. So you need a very different paradigm, a very different approach to dealing with digital markets than you do with traditional markets. And which is why, as I said, around the world, competition law is evolving to deal with that.
All right. You've spoken about also the need for some of these big tech companies or these large intermediaries to inform the CCI and the government about any mergers and acquisitions, about any market concentration that takes place. What is the importance of identifying some of the players who could have a negative influence in the market?
Well, there's a term that's used in digital markets called a killer acquisition. So we don't want big tech companies to make a killer acquisition and kill competition in markets that are evolving. And there are many such examples of that, of course. As you know, YouTube was purchased by Google, WhatsApp was purchased by Facebook. And so what happens is that big tech companies that are very high market cap companies, have plenty of cash, are able to make such killer acquisitions that then ends up choking off competition in adjacent markets. So to prevent these kinds of killer acquisitions, both the competition law, which now has a deal value threshold of 2,000 crores, as well as the Digital Competition Act that we are proposing, has provisions for the Competition Commission of India to very carefully scrutinize the actions of big tech companies to ensure that competition is not being choked off in this fashion.
Right. You've also flagged at least 10 areas where anti-competitive behavior needs to be checked. Which would be some of the most important there? One of them is an anti-steering provision.
Yes, that is correct, Parikshit. In an anti-steering provision, the goal would be to prevent digital intermediaries, digital platforms, to steer people to their own associated services. So a very good example, of course, is the App Store. So both Apple and Android have very large app stores. And right now, the only way largely you can get an app is through their App Store. Certainly with Apple, it's very difficult to buy an app any other way. In Android, there are alternatives, but because of the way the steering is done, most people prefer to buy apps from the Android Play Store. So therefore, these anti-steering provisions are necessary to ensure that customers have choice, that they have a level playing field. But similarly, there are pricing discounting measures that we think are important to keep an eye on. It's very important to ensure platform neutrality. Data usage should also be free and fair. We want to make sure that bundling and tying is not done in such a way that it chokes off competition in adjacent markets. So we've identified 12 of these anti-competitive practices, which have been seen in India. We got many people complaining about them, and they are well established in international competition law as well. So in these digital markets, from these systemically important digital intermediaries, we are seeing these kinds of anti-competitive practices, and therefore it's important as regulators to ensure that we have contestable markets and free and fair choice for consumers, that these kinds of provisions be considered.
How important is it to harmonize laws with what's happening globally? And are you urging the government to take a cue from the EU Digital Markets Act and their gatekeepers policy?
Harmonization is very important because we want to be able to go to these very important players in our modern 21st century economies, particularly our digital economies, these big tech companies. And we have to tell them that these are being done with the best of intentions to ensure contestability, to ensure fair competition, to ensure consumer choice. And if, various important jurisdictions, of which India, of course, is one of the world's leading digital ecosystems, and the EU, and hopefully other countries like the US as well, all of them come forward and show them, the big tech companies, that there is a way of ensuring free and fair competition, then it's something that we think will get implemented and will be successfully implemented as well. So building consensus on these issues, particularly for India right now, because of our G20 presidency, where digital public goods and digital ecosystems are a very important priority for us. Building this kind of harmonization, building this kind of alignment is a very important geopolitical priority for us as well.
All right, so that was Jayant Sinha, Chairman of Parliamentary Committee on Finance, also telling us that the competition law must be strengthened with a digital markets unit to improve its ability to regulate digital markets. I'm now joined by well-known cyber law expert NS Nappinai. Ms. Nappinai, thank you for being with us. You heard Jayant Sinha there. You've seen the report as well. But give us a sense, is this really the need of the hour? This is a debate going on all across the world. European Union has come up with a Digital Markets Act. The law is evolving in the United States as well. Some aspects of these laws will unfold in the months to come. How important is for India to act as per global practices?
There are two parts to your question, Parikshit. So the first one, is this law necessary? Absolutely. Is this the right time for this law? We are already late. So I would say, as in terms of law, whenever we get something to be done, like giving an opinion, etc., the clients will always say, we want it by yesterday. So when it comes to this law also, I would say that we needed it yesterday, not just in the future. So the sooner we get this, the better. And you raised some very critical queries when you were asking Mr. Sinha questions. And one of them is harmonizing the laws. And that brings me to the second part of your question also. Digital by its very nature is something that we need harmonized soft laws ideally to follow. But since there has been a time lag in terms of us getting sufficient soft laws to cover various soft subjects, forget about the hard subjects like cyber crimes, etc., but even soft subjects like this, like a Digital Markets Act, etc. What the best we can do as a national regulatory mechanism is to try and ensure that not only is there harmony in terms of the regulatory frameworks between multiple nations, but that which diverges from it may be an addition, a supplement to it, and not a contrary provision, which will then critically impact enforcement when we are talking about big tech and large players who already are having their presence in multiple jurisdictions. So in doing this, I would say that there is absolutely no harm in drawing from existing legal frameworks, but it should be customized also to the needs of the nation and not just be blindly adapted.
Right. So, Ms. Nappinai, coming to the point that Jayant Sinha also made and is mentioned very clearly in the report, is identifying companies which can significantly influence the marketplace in the digital sphere. Term them, identify them as systematically important digital intermediaries. Make sure it's mandatory for them to apprise the CCI and the government of any M&As or market concentration that they undertake. Do not use any data that's not publicly available. Submit an annual record to the government as well. How important is this? How feasible is this? Or how right is this in the Indian context?
Very long but very critical question. And yes, it's definitely feasible, because if you look at the SEBI Act and how it functions, we have similar provisions for companies which are registered in India in terms of, for instance, you spoke about aggressive takeovers. So when you're doing an aggressive takeover, you must have a disclosure already. There are certain do's and don'ts in terms of what is permissible in terms of takeovers and what is not. The second part of your question deals exactly with similar SEBI provisions for insider trading, right? You cannot use inside information to manipulate markets. So all these are regulatory frameworks which are existing for corporate entities, which are registered in India. In a way, what Mr. Sinha's statement seemed to indicate was that this is being expanded to include big tech, which has a large presence in India, whose actions are going to impact consumers as well as businesses in India, but who may not be amenable to the market laws, which are otherwise applicable to local businesses. So in that sense, in terms of enforceability or feasibility of enforceability, I would say it's definitely workable, it's doable, because it's more of a compliance framework rather than just an enforcement aspect. And that is where you get that ex-ante aspect also, which you have already discussed earlier. So when you want to do something in a preemptive manner, the only way you can do it is not like the minority report kind, but more like a compliance mechanism where you forecast what is likely to happen and then you put in certain compliance frameworks where companies which fall within the categories have to report in advance. So the basis on which such reporting has to happen, the content that will form part of the reports, and the mode and manner in which it is to be applied with are all transparent and therefore actually help business. It's not like a stumbling block. I would say this is actually very good for big tech also, because right now they are already seeing the kind of trends in terms of very large orders against them from the Competition Commission of India already. So to preempt that and to make sure that they also function, they're ring-fenced in their functioning in India and do not take things for granted, it's very important, both for consumers, for small businesses, and actually for big tech.
Right. Ms. Nappinai, would there be any provisions mentioned in this report which could be excessive? Because, again, in the budget, the focus will be on ease of doing business. Do you think there is any point that runs contrary to that? And secondly, this calls for a new legislation. Can it be included in the competition amendment law, or will we now have to bring a new law to Parliament?
If I could take the second question first, Parikshit, because it's actually a very critical issue. Now, there is an amendment that is put before the Parliamentary Committee to the competition laws of India. And then you have a report which talks about possibly a standalone law. The difficulty that will arise if you have a standalone law is then, are you going to have a separate regulatory mechanism? Are you going to have a separate enforcement authority under it? Or is it still going to come under the Competition Commission of India? And if there is going to be a separate authority, will there not be a clash between the Competition Commission of India and also the new regulatory authority? So in order to ensure that we are not creating more turfs and therefore more turf wars, and we've already seen that between existing tribunals or special authorities, etc. So one, I would ideally say that this juncture, since we already have a robust mechanism under the competition laws, we already have seen various cases decided and large awards that have come out, and the competition authority is well equipped to deal with these kind of cases. Additions to the existing competition laws by way of amendments would be preferable instead of starting from scratch in establishing a separate authority. But whilst this may be so, there may be certain aspects of it which may have to be carved out and given to a regulatory authority, not an enforcement authority, but a regulatory authority, which will primarily be the ex-ante provisions, which will be more in the form of a compliance process rather than an enforcement mechanism. So since the competition authority deals with it like the court, I'm just trying to simplify it. Since it deals like, it decides cases, it should not also be the regulatory process which will be setting down the methodologies which the big tech have to comply with. And therefore, that delineation may be available. But to make two parallel competition authorities may not be such a good idea. As far as the first part of your question is concerned, yes, of course, there will be some issues in terms of excesses in terms of the proposals, but that's why that's still pending for consultation and public review and responses, hopefully. But broadly, I would say that the hits far outweigh the misses.
All right, so hits far outweigh the misses. Thank you very much, Ms. Nappinai, for joining us and telling us what could be the road ahead now that the Parliamentary Committee has presented its report in Parliament. We're going to take a short break here on News Centre. Don't go anywhere. More news and updates on the other side.